Nahmaduhu nusalli ala Rasulil Kareem. Auzu billahi minash shaitanir rajim. Bismillahir Rahmanir Rahim. My name is Nasir Ahmed and I am the moderator for this webinar on Islamic Will and Estate Planning session by Brother Lawyer Muezzin Qureshi. On behalf of Islamic Society of Markham and its two chapters, Jami Masjid Markham and Masjid Darul Iman, I welcome you all for this webinar. Jazakallah khair to Brother Muezzin Qureshi for his presence and for his time and efforts in speaking at this webinar. Inshallah, through this webinar, you will gain an understanding of what an Islamic law of inheritance is and also what an Islamic will encompasses, and also provide you with insight on the Ontario inheritance law. As this is a video streaming, we will inshallah take your questions on our Masjid Darul Iman WhatsApp broadcast number 647-995-7000. This number is on our website daruliman.org as well. Before I hand over the mic to Brother Muezzin Qureshi, I would like to give you his brief introduction. Brother Muezzin Qureshi has been practicing law from 2002 and in Ontario from 2012. He is specialized in Islamic inheritance law as well as Ontario inheritance law. At the end of this session, we will inshallah answer your questions as well as share the presentation with the registered participants through email. Once again, thank you so very much for joining this webinar. I will now hand over the mic to Brother Muezzin Qureshi. Assalamu alaikum.
Auzu billahi minash shaitanir rajim. Bismillahir Rahmanir Rahim. Assalamu alaikum, everybody. I'd like to start with a short brief dua. Rabbi ishrah li sadri wa yassir li amri wahlul uqdatam min lisani yafqahu qawli. I'd like to start by thanking all of you for attending and participating in this session. Also, a special thank you and Jazakallah khairan to Brother Nasir Ahmed and all the organizers and all the people who volunteer their time and effort to make these webinars happen, to make these programs happen. During this time of crisis that we are going through, we have begun to appreciate, many of us have begun to appreciate even more the importance of the masjid in our daily lives and our ability to come here, to congregate here, and to share with the community. Inshallah, all of this will be over soon, but even during this period, the administration, the brothers, Imam Arif Desai Sahab, all of them are putting in tremendous effort to ensure that the community is engaged, to ensure that very good programs are shared with all the members of the community. So Jazakallah khairan for that. This session on Islamic law and laws of inheritance in Canada. Sorry. Thank you, Brother Nasir. This session is going to be, the purpose of this session is going to be a general introduction to laws of inheritance. I will speak briefly about what a will is, what are the essential components of a will and an estate plan. I'm going to cover what the estate is, who some of the essential people involved in estate planning or involved in wills are, and I'm going to be discussing the relevant laws in Ontario. Now, with respect to this, you all have an understanding of what a will is. A will, according to the law of Ontario, is a written document which sets out a person's wishes as to how they wish for their wealth to be distributed upon their death. That is a single document. It is known as a will, but it becomes a part of something known as the estate plan. The estate plan is every individual's plan to cater for a situation or a scenario where they are unable to make essential decisions for themselves, whether it is during their life or after their death. So an estate plan, for instance, includes a will, which takes effect after a person passes away, but it also includes a power of attorney for property, and it also includes a power of attorney for healthcare. So, for instance, if somebody has been in some kind of catastrophic accident and they are unable to make essential decisions about their health as to whether or not certain procedures should be performed on them, or they are unable to attend to essential matters, the powers of attorney for healthcare and the powers of attorney for property become necessary. They become very useful at that point. Then we talk about the estate. When we talk about laws of inheritance or laws of succession, we talk about the estate. What is the estate? The estate basically is the entire wealth that is left by a person upon their death, the wealth that belongs to a person upon their death. This wealth can be in various different forms. It can be in the form of cash. It can be in the form of money lying in a bank account. It can be in the form of property. It can be in the form of gold. It can be in various different forms. Shares in corporations. It can be any of this. All of this together, liquidated or even unliquidated, collectively is known as a person's estate. Now, when we are dealing with laws of inheritance or when we are dealing with wills, there are some essential people who are involved over here. There is firstly the person who has passed away. He or she is known as the deceased, that is the testator. There is then the person who steps in to administer and to take care of and to distribute everything that was a part of the deceased person's estate. That person is known as a trustee. That person is also known as an executor. These are the terms that are used primarily in Canada. Um, there are slightly different terms that are used in other jurisdictions. So, for instance, in the US and in England and in South Asia, they may have different terms, but essentially the role and the function is the same. Then there are the beneficiaries. The beneficiaries, or there can be a singular beneficiary, these are the people amongst whom the estate must be distributed. It can be a singular person or it can be many, many people. And it is also possible for one or more of the beneficiaries to also be the trustee or the executor. So they can be the person who is administering the estate and also be the person to whom the estate will be distributed. Also in Ontario, when people have an estate plan and they've got young children, they can also nominate a guardian for their minor children. This is somebody who, for a 90-day period, will have guardianship over minor children if both parents of minor children are not alive. And after 90 days, there is a court order that is required to confirm and to validate the appointment of that guardian. The relevant laws in Ontario which deal with any aspect of wills and any aspect of inheritance or laws of succession are the Succession Law Reform Act. This is an Ontario law which sets out how the estate of a person is to be distributed upon their death. There is a law known as the Estates Act, which which deals primarily with how the estate will be administered, not who it will be distributed to, but rather how the estate itself will be administered, how and when the debts must be paid out, and how the distribution must be done, and if there are immovable assets, how will they be liquidated, so on and so forth. And then there is the Family Law Act, which has some bearing on the laws of inheritance, because if the person who passed away was a spouse, certain rights of the surviving spouse are protected, and that is covered under the Family Law Act. I will, during this presentation, inshallah, I will be sharing with you the Sharia on inheritance. I will then be speaking briefly about the relevant laws in Ontario, and I will then try to address how Muslims living in Ontario need to take certain steps, how they need to make their wills so that they are A, first and foremost, compliant with Sharia. They adhere to the prescriptions of the Sharia on inheritance, but B, are also compliant with the law of Ontario so that those wills that they make can be implemented, they can be enforced, and become, they do not get challenged or they do not become disputed because of any kind of defect in the will. Um, so there are a number of verses in the Holy Quran which address or which pertain to the issue of inheritance. Some of the important ones that I'd like to point out, it's not possible for me to list out or to discuss or to go each of them, that would take too much time, but some of the significant ones that I would like to address and speak about. Surah Baqarah, chapter number 2, verse number 180. This gives us verse number 180 gives us the significance or the importance of having a will. Prescribed for you when death approaches any of you, if he leaves wealth, is that he should make a bequest for the parents and near relatives according to what is acceptable, a duty upon the righteous. It continues, verse number 181 of Surah Baqarah. Then whoever alters the bequest after he has heard it, the sin is only upon those who have altered it. Indeed, Allah is hearing and knowing. So these two verses tell us how important or what the significance of having a plan or of making sure that there is a proper distribution of wealth after a person passes away is, that it should focus on the parents and on the near relatives, and if anybody interferes with that distribution of wealth, then that is a grave sin. There are then a number of verses in Surah Nisa, chapter number 4 of the Holy Quran, where the ways in which the distribution is to be made are set out. What the various rules of the distribution are set out in detail. So we look briefly at verse number 11 and verse number 12. Verse number 11 says, Allah instructs you concerning your children, for the male, what is equal to the share of two females. But if there are only daughters, two or more, for them is two-thirds of one's estate. And if there is only one, for her is half. And for one's parents, to each one of them is a sixth of his estate if he left children. But if he has no children, and the parents alone inherit from him, then for his mother is one third, and if he had brothers or sisters, for his mother is a sixth, after any bequest he may have made or debt. Your parents or your children, you do not know which of them are nearest to you in benefit. These shares are an obligation imposed by Allah. Indeed, Allah is ever knowing and wise. And then it continues like this with verse number 12. There is verse number 176. So in Surah Nisa, there are various verses which set out the rulings which apply to the distribution of a person's estate upon his death. Now, in many countries of the world, uh, Muslim majority countries, people do not need to go into a very deep or detailed understanding. There is no necessity for them to take action because the laws of that country automatically allow. So, for instance, if a person in Saudi Arabia, in Dubai, in Pakistan, for instance, if a person passes away in any of these countries, there is an automatic procedure whereby the law of that country allows the distribution to take place as per Sharia. But of course, we do not have that in Ontario. So it is necessary for us to get an understanding of what the laws of distribution according to Sharia are. And once we have some understanding of the law of inheritance and wills in Ontario, to make sure that our wills in Ontario take into account the Sharia on succession and to follow them. Now, in to give some context to all the rules of the Sharia law on succession, there are two key issues that the Sharia on succession tries to address. They are that there must be laws which pertain to distribution of wealth amongst heirs, so that there is certainty of distribution and the heirs don't fight amongst themselves. This is, in other words, this is not something which should be left to whoever is stronger and whoever has greater might can go and grab and usurp for themselves whatever should actually be distributed amongst the proper heirs. The second key issue in any part of the Sharia on succession and inheritance is that there must be a just system so that wealth is not accumulated or it is not usurped by a single entity or by a single person, but rather there should be a fair distribution of the wealth amongst the people who are lawfully entitled to it. You know that in pre-Islamic Arabia, there was a tribal and a patriarchal society. The tribe and the head of the tribe would rule. Quite often, when a person passed away, leaving only a spouse and children, the spouse and the children would get nothing. The head of the tribe would get everything, or the male agnatic head of the family would get everything. His wealth would increase, whereas the orphans and the widow, they would be left destitute and no provision would be made for them. Of course, Islam brought about tremendous reform in this so that there was a just distribution of wealth, there was no hoarding of wealth, and the orphans would get their lawful whatever was due to them. So there are certain general considerations which are followed in Islamic law of inheritance. The first is that there must be a break in the concentration of wealth and there must be greater distribution of wealth in society. The right of ownership of an individual to his wealth that has been earned through legal means must be respected, and it is not for the tribe or the head of the family or for the head of the tribe to confiscate a person's property after his death. Rather, his property should be distributed amongst his immediate family members. Uh, the Sharia on succession also endorses and consolidates the strong family system by ensuring that there is a distribution of wealth amongst the family members. There is a recommendation for individuals to write their will, and there are details of inheritance law which educate us that we are not absolute master over our wealth. Rather, it has been given to us by Allah subhanahu wa ta'ala as an amana, as a trust that we are authorized to spend only according to His instructions. Another consideration is that it provides peace of mind for everybody in society, knowing that after their death, their family will be given their due right of inheritance and they will not be left destitute. And lastly, there is a special focus on women's inheritance, as previously women were denied the right of inheritance, and this is a problem that even today persists, unfortunately, in patriarchal societies. Now, if we are to understand the law of distribution of an estate or succession under Sharia, it is actually a three-step distribution. The first part is that a person's debts and funeral expenses must be paid out right at the outset. So if a person passes away and they have an estate, but prior to the death, that person had a debt, that debt must be paid out before there can be any distribution of wealth. Also, if a person wishes, they can, under Sharia, leave up to one third of their wealth to anybody that they wish to do so. So, for instance, if a person wishes to leave a part of their wealth for the masjid, for a community organization, for an organization which they know is doing a lot of good work in the community, if we look immediate at our immediate, you know, situation, um, Masjid Al Iman comes to mind as an organization which is doing tremendous amount of work for the community. It is a masjid, it is a house of Allah. So if a person wishes to leave up to one third of their wealth under their will, they may do so. And as long as it is not for an improper purpose or it is not to an improper body or something like that, that must be respected. The second step is there are 12 Quranic heirs. These are those 12 people who have been nominated in the Quran, whose shares have been prescribed by the Quran itself. And therefore, there must be a distribution of wealth first amongst the Quranic heirs according to whatever formula is or whatever share is prescribed for them. And after these two steps have been completed, whatever is left, the residue of the estate, has to be distributed amongst the male relatives according to what are known as the rules of agnatic inheritance. So it goes to the closest male relative from the family of the deceased. We look first at the we look first at the Quranic heirs. There are 12 Quranic heirs. For each of them, there is a prescribed share. Each of them, or some of them rather, can be excluded by the presence of another. Some of them have a share which can get affected by the presence of another. So, for instance, there is the husband. The husband's share upon his wife passing away is one fourth. He cannot be excluded. The husband's share cannot be excluded by anybody. Also, his share will not be affected. His share will be affected if there are no children. If there are no children, the husband's share will double, and from a quarter, it will become half of the estate of the deceased after all the expenses and after any one third share that has been left in a will has been distributed. So, whatever the residue is, whatever is left, one fourth of that will go to the husband, and if there are no children, it will double to a half. Similarly, if a male passes away, his wife will get 1/8 of the estate. If there are no children, her share will be doubled to become 1/4. The father is entitled to 1/6 of the estate. If the father cannot be excluded by anybody. There is no superior heir whose presence or who being alive at the time of the person's death can exclude him. And if there are no children, then the father will be agnatized. Agnatized means that whatever residue is left will go over to the closest male agnate relative. There is the grandfather who also gets 1/6, but we see that in the case of the grandfather can be excluded by the father or by a closer grandfather. So if a person passes away and they are survived by a husband, a father, and a grandfather, the husband will receive 1/4, the father will receive 1/6, but the grandfather will be excluded because of the presence of the father. But of course, if there is no father or there is no closer grandfather, so for instance, a great grandfather would be excluded by a grandfather. If there is no father, there is no lower grandfather, and the person who passes away did not have children, then the grandfather will inherit the residue as an agnate. The mother's share similarly is 1/6. The mother cannot be excluded by anybody. However, if there is no children of the person who passed away, the mother's share will become 1/3. Similarly, if the person who passes away only leaves one brother or one sister, not more than one brother or sister, the mother's share will become one third. If a person passes away and they leave their father and their mother and a spouse, whether it is husband or wife, then the mother will get one third of the residue after the husband has taken his share or the wife has taken her share and the father has taken his share. The grandmother's share is 1/6. The grandmother is excluded by the mother or the nearer grandmother. I would like to point out at this point that the grandfather and the grandmother, these are exclusively maternal grandfather and paternal grandfather and paternal grandmother, which means this is the grandfather and the grandmother from the father's side. This does not include the maternal grandfather or the maternal grandmother. The daughter's share is half of the entire estate. And if there are two of them, then collectively the daughters will inherit two-thirds of the estate. The daughter cannot be excluded by anybody. However, if the person who passed away left a daughter or more than one daughter and at least one son, then the daughter will no longer inherit her Quranic share of half, or if there is more than one daughter, two-thirds. Rather, the daughter will inherit whatever the residue is together with the son in a 2-to-1 ratio. The son getting two parts and each daughter getting one part. So, for instance, if a person passes away and they have two sons and three daughters, the total number of shares will be 7. Each son will get two parts out of 7, and each daughter will get one part out of 7. And just to go back very quickly, just to recap very quickly, the distribution of a person's estate under Sharia is divided up into 3 steps. The first one is the payment of debt and funeral expenses and any bequest made by the person who passed away up to one third. And then whatever is left is distributed amongst these through these rules and these formulas that we are looking at right now for the Quranic years, the 12 Quranic years. And after that, after the Quranic heirs have gotten their share, whatever residue is left is given amongst the male relatives as per the rules of agnatic inheritance. So when we say that the daughter is going to be agnatized by the son, what that means is that she will no longer get her share of a half as per the Quranic share, but rather whatever the residue is left after the Quranic heirs have taken their share, she will get the residue in a 2-to-1 ratio with her brother. The son's daughter. A son's daughter, similar to a daughter, will get half. If there is two or more, then it will be two-thirds distributed amongst them equally. This is the granddaughter, the son's daughter. However, a son's daughter will be excluded by a son, any son. So, for instance, a person passes away and the person has two sons. One son is alive, the other son is not, and they have two daughters left. Then the second son who's passed away, their daughters will not get the Quranic share that is prescribed over here. If there is more than one daughter, or if there is more than one higher son's daughter, then the son's daughter will be excluded outright. So I repeat to recap, the son's daughter's share is a half. She is excluded entirely by the son, and she is similarly excluded if there are two or more daughters. However, if there is just one daughter, then the son's daughter will get 1/6, and the daughter will get her half share, which collectively becomes 4 parts out of 6. If there is an equal son's son, then the son's daughter will be agnatized and she will inherit in a 2-to-1 ratio, just like the daughter and the son will do. The full sister's share is half. If there are two of them, they will get 2/3 between them. A full sister is excluded by the presence of a son, by the presence of a grandson, by the presence of a father, or the presence of a grandfather. If there is a full brother, or there is a daughter or son's daughter, then the full sister will be agnatized and not inherit her Quranic share, but rather inherit as an agnate. Then there is the consanguine sister. Consanguine sister means that the father of the person who passed away and the father of the sister is the same. They have the same father. It is a consanguine sister, and her share is a half. If there is two or more of them, they will share 2/3 between them. A consanguine sister will be excluded entirely by the son, by the grandson, by the father, by the grandfather, by a full brother, or more than one full sister. If there is just one full sister, the consanguine sister will get 1/6, whereas the full sister will get half. If there is a consanguine brother, or there is a daughter or a son's daughter, the consanguine sister will be agnatized. Then number 11 and number 12 are the uterine brother and the uterine sister. These are the brother and the sister of the deceased who had the same mother as the deceased. For each of them, if there is just one, it is 1/6. If there are two of them, then collectively 2/3. They are excluded by any child, a son or a daughter, or any son or daughter of a son, or by a father or a grandfather. Now, these 12 Quranic heirs, their shares, who they are excluded by, who they are affected by, if they are affected, how will they be affected? This can become very complex, but we will, inshallah, later in this presentation, look at a few scenarios where a person passes away and how the distribution will take place according to Sharia. Then, after the Quranic heirs have been given their share, there is the agnatic inheritance. Under the rules of agnatic inheritance, all the residue that is left after the Quranic heirs have gotten their shares goes to the closest male agnate. And there are three rules which have to be followed. The first one is that preference is given to the order. First in priority are descendants, so that includes a son, a grandson, so on. Second in priority are ascendants, which means father, grandfather, great grandfather. And third in priority are the collaterals. So if a person passes away and they are survived by a son and a grandfather and two brothers, then according to the rules of agnatic inheritance, the first priority will be given to the descendant, which is the son, and the son will therefore exclude the ascendants, the father, and the collaterals, which are the two brothers. And therefore, under agnatic inheritance, everything will go to the son to the exclusion of the father and the brothers. The second rule that is applied is that if within a particular group, within the descendants or the ascendants, you have more than one person, then the closer in degree is given preference. So if a person is survived by a son, a grandson, a father, and two brothers, under the first rule, the father, the grandfather, any brothers, they will be excluded by the presence of the son. And under the second rule, the closer in degree, which would be the son, would exclude the grandson. The third rule which is applied is that the real blood prevails over the consanguine blood, which means consanguine means that there is a common father, and the consanguine prevails over the uterine, which means that there is a common mother. So if a person passes away and they have got a real brother and they've got two brothers, one of whom is a consanguine brother, and they've got a total of three brothers. One of them is a real brother, uh, the second is a consanguine brother, and the third is a uterine brother. Then the real brother will prevail over the other two, and everything will go to the one real brother. Lastly, if we are distributing according to the rules of agnatic inheritance, then if there is a son and a daughter, everything goes between them in a 2-to-1 ratio. If there is a son and a daughter, or if there is a brother and a sister, everything is distributed amongst them in a 2-to-1 ratio. Now, there are certain disqualifications, there are certain rules which will apply to disqualify a person from inheriting under Sharia. The first is that a Muslim cannot be the heir of a disbeliever, nor can a disbeliever be the heir of a Muslim. So if a Muslim passes away and they have got somebody who is otherwise entitled to a share in their estate, but is a non-Muslim, is a disbeliever, then they will lose their right to inheritance. Another rule is that a person who kills somebody or murders somebody cannot be an heir and cannot inherit from them. All the jurists have agreed that intentional or unjustifiable killing according to Sharia is a complete bar to inheritance because, of course, if such people are allowed to kill and then benefit from the estate of the victim, it will encourage incidents of homicide. Also, it's very important to note that it is only relatives with a legitimate blood relationship to the deceased who are entitled to inherit from the estate, who are entitled to inherit from the deceased under Islamic law. Therefore, illegitimate children, the children of a spouse from another partner, adopted children have no part in inheritance according to Islamic law. If a person is married and their spouse has a child from a previous marriage or a previous relationship, then according to this person's will or according to this person's estate, the child will not have any right of inheritance. I'd now like to speak briefly about the Ontario Law of Succession, the Succession Law Reform Act, and the Estates Act, and then discuss with you how we can prepare a will in Ontario according to Sharia and make sure that it is enforceable. Um, Under the law in Ontario, there is clearly a distinction between testate and intestate succession. The division is between testate succession and intestate succession. Testate succession basically means that a person has created a will before their death, and whatever succession will occur will happen through their will. Intestate succession is that a person did not create a will before their death, and then there are certain specific rules that will apply as to how the succession will take place. So we talk first about testate succession. In testate succession, as a general rule, you have complete discretion and complete ability to leave whatever you wish to whosoever you wish. There are certain restrictions, constraints upon that. The first constraint is who has the capacity to make a will? Who has the capacity to make a will that is recognized and will be upheld and enforced in Ontario? Very simply, a person must be an adult. They must be 18 years of age or older. Number two, they must have the mental capacity to make the will. A person who lacks mental capacity, a person who is unable to understand what they are doing because of disease or because of mental incapacity, does not have the capacity to make a will. Thirdly, any will that is made under duress, that is made under coercion, or that is made uh, by way of fraud will not be upheld. It will not be, um, held or considered valid in Ontario. Then there is certain restrictions on a person's discretion to make a will and to leave whatever they wish to whoever they wish under Ontario law. there are two provisions which apply restrictions on a person's discretion. The first is the spousal claim under the Family Law Act. Under the Family Law Act, when a person passes away, that person's spouse can immediately make a claim in the family law courts for equalization. And therefore, if a person has created a will and under that will they have left 1/6 to their father and they've left, half to their daughter and they've left just 1/8 to their spouse, the spouse can make a claim in family court for equalization, the result of which would be that the entire estate would end up going to the spouse, and the father and the daughter would possibly get excluded. There are certain ways to overcome that. When people make a will and they are leaving anything other than the entire estate to their spouse, they can have what's called a marriage contract or a domestic contract in which they both agree to uphold, to respect, and to abide by the distribution of wealth in their spouse's will and not make any claim for equalization upon their death. Another restriction on a person's discretion under Ontario law is to ensure that they've made provision for dependents. So, if a person under Ontario law wishes to leave everything in their will to the Conservative Party of Canada or to Justin Trudeau or to any political party or anybody, and they have dependents, those dependents can be a spouse, those dependents can be children, those dependents can be other people that depend on them for financial support, and no provision is made in the will for those dependents, then that will have to be restricted because it does not adequately provide for distribution amongst the dependents. So these are some of the restrictions um, on a person's discretion to make a will. But again, very simply, under Ontario law, a person can make a valid will. They are an adult. They have a written will. They comply with whatever the requirements of making a valid will are. They can make a will. They can leave whatever they wish to whoever they wish. There is no restriction. There is complete and absolute discretion. Your discretion is limited only by two things. One, the spouse's claim, if the spouse survives a person, the spouse's claim under the Family Law Act for equalization. The way to circumvent that is by executing or entering into a marriage contract or a domestic contract. And the second restriction on discretion is that you must, in your will, make a provision for dependents if there are people, children, or others who are financially dependent on you. Then, after testate succession, we see there is intestate succession. Intestate succession is that when a person passes away, they did not have a will. How will the law allow or provide for their estate to be distributed? Right at the outset, I have to make it very clear there are a number of people in Ontario who are under the mistaken belief that if a person does not have a will and they pass away and they have any wealth, the entire wealth goes to the government or it goes to the crown or it's taken away from the family. That is not the case. That is certainly not the case. When a person passes away, there is a number of rules that are set out in the Succession Law Reform Act as to how distribution will take place under intestate succession. The first rule is that if the person has a spouse, the spouse will get the first $200,000 up to a value of $200,000 from the estate. So if a person passes away and they have a spouse and they have children, the first $200,000 of the estate will go to the spouse. This is known as a preferential claim. And after that, if there is a balance, so if a person passes away and they have $300,000, the first 200,000 will go to the spouse, and the balance, which is 100,000, will be distributed between the children and the spouse. If there is just one child, half to the spouse and half to the child. If there is more than one child, then 1/3 to the spouse, and the remainder will be distributed equally amongst the children. If there is more than one child and one child has passed away and left their children, then that predeceased child's children will inherit the same way as their parent would. So, for instance, a person passes away, he is survived by his wife, he is survived by two sons, and the grandchildren from another child who has passed away. The first 200,000 will go to the wife. The balance will be taken, one third will go to the wife. The remaining two thirds of the balance will be distributed equally between the two surviving children and the children of the children of the child who has predeceased. If a person passes away and they have children and they have no spouse, then the children will get an equal share distributed amongst them. There is no provision in here for the parents. Everything will go entirely to the children. Again, if any child is predeceased, then the children of that predeceased child will get their parents' share. If a person passes away and there is neither a spouse nor any children of the person who passes away, and they have one or both parents, then the entire estate will go to either of the parents who are alive. After that, if a person passes away and they do not have a spouse, they do not have children, and they do not have any parents surviving them either, then everything will go to their siblings, brothers and sisters. It will be distributed equally amongst them. Of course, there is no 2-to-1 ratio here. Everything will be distributed equally amongst them. And if there is one particular sibling or more than one who has passed away, and that sibling had children, then that deceased sibling's share will still be distributed amongst their children. This is known as the per stirpes rule of distribution. And if a person passes away and they do not have a surviving spouse, they do not have any children, their parents are not alive, and they did not have any siblings alive at the time of their death either, then the law will look for their closest family members, such as cousins, such as nephews, nieces, uncles, and aunts, and it will be distributed amongst them. It is only if a person has no immediate family members, no next of kin, no family members that can be found, that everything will go to the estate, will go to the crown. Everything will be then distributed to the crown. Now, testate succession under Ontario law is very important, and I've spoken briefly about that before. There are certain things that need to be understood. The first is who has capacity to make a will. As I've said before, it is an adult, must be 18 years old or more, must have no mental disability. There must be no coercion, no duress, no force applied on them to make a will. So if a child puts a gun to the parent's head and says make a will and leave everything to me, that will of course will not be upheld, and it will likely be dismissed by the court. The will must be in writing. So Ontario law does not permit an oral or verbal declaration of a will. So a person communicating or recording a message or a video of some kind and saying, this is my will and this is how I wish to leave everything, that is not valid. It will be treated as intestate succession. The written will must be signed by the testator, the person who is creating the will, and it must be witnessed by at least two witnesses. Those witnesses cannot be beneficiaries under the will, nor can they be the spouse of a beneficiary. It is usually very useful and important to have what is called an affidavit of execution sworn by a witness. So the witness makes a sworn statement that I was present on such and such date when such and such person created their last will. I saw that person execute that will, and I am the witness to that will, and I witnessed that person executing that will in my presence and in the presence of another witness. There is something known as a holograph will A holograph will is a handwritten will. There are certain special rules to prove or establish such a will in court. There is a special kind of affidavit which must go there. A codicil is any amendment that is made to a will. So if a person in January 2020 makes a will and in July of 2020 they wish to change something in their will, they can do so by making a codicil, and all the requirements of a codicil are the same as a will. So they can either terminate their previous will and make a new will altogether, or they can simply have a codicil. Their original will remains intact, but the codicil will make certain changes to it. Sharia permits oral statements of their will and oral testament, but oral testaments, as I said briefly before, cannot be enforced under Ontario law. Now, this next part of this presentation is perhaps the most important, which is that we look at a number of scenarios where we see how a person's estate will be distributed under Ontario law and how it ought to be distributed under Sharia. So a person passes away. This is the first scenario. A person passes away, and the person is survived by his wife, by his father, and his mother only. Now, under the Ontario law of intestate succession, everything will go to the wife, and the father and mother will inherit nothing, and there is no distribution of the estate to the parents. But under Sharia, it's completely different, because under Sharia, the wife will inherit 1/4 of the entire estate. The mother will inherit 1/3 of the 3/4 residue. So after the wife has taken her 1/4 of the estate, the mother will get 1/3 of the remaining 3/4, which means that she will also get 1/4 of the estate. And the father similarly will inherit half of the estate as the agnate. If you recall, I'll just go back very quickly. If you recall, the share of the wife is 1/8, but if there is no child, her share becomes 1/4. The share of the mother is 1/3 if she coexists with a spouse. So it is 1/3 of the remaining 3/4, and the share of the father is everything according to the laws of agnatic inheritance. So we see that what a contrast there is between how the distribution would take place under Sharia and how the distribution would take place under the Ontario interstate succession. Another scenario is a person passes away and they are survived by two sisters only. By a father, I'm sorry, a person passes away and they're survived by a father and two sisters only. Under the Ontario law of interstate succession, the father will inherit everything. The entire estate will go to the father, nothing will go to the sisters. But under Sharia, the father will inherit 1/3 of the estate, whereas the sisters will get 2/3 to be distributed equally between them, meaning they will get 1/3 each of the person's estate. Another scenario is a person passes away and is survived by a wife, a daughter, and a son. Under the Ontario law of succession, if the value of the estate is $200,000 or less, the wife will get everything and nothing will be left for the children. However, if the value of the estate is greater than 200,000, the wife will get the first 200,000, and she will also get 1/3 of whatever is left after she takes the first 200,000. So $400,000, she will get the first 200,000 plus 1/3 of the remaining $200,000. And the son and daughter will share the 2/3 of the residue after their mother has taken everything equally between them. Under Sharia, in the same scenario, the wife would inherit 1/8 of the estate. The daughter would inherit 1/3 of the residue, which is 7 parts out of 8, 1/3 out of 7 out of 8. And the son would inherit 2/3 of the 7 by 8 residue. So again, under Sharia, the wife would inherit 1/8 of the estate. The residue would be 7 parts out of 8 of the estate, and the daughter would get 1/3 of that residue, and the son would get 2/3 of that residue. Now, we see a conflict between how one can implement their Sharia obligations through a will and Ontario law. The first one is that the spouse has the right to claim equalization under Family Law Act. When a spouse makes a claim for equalization, she can frustrate a person's will. So if a person has made a will and in that will they have set out how the distribution should be made as per Sharia for the parents, for the siblings, for the sons, for the daughters, for the sisters, how all of that is done, then if the spouse so wishes, she can frustrate that. The way to circumvent that or the way to ensure that that does not happen, of course, is through a marriage contract, or, of course, if there is that trust and confidence between both spouses that the spouse would not do something like this to frustrate the provisions of the Sharia in the will. Also, a matrimonial home cannot become a part of a person's estate. It is possible that the matrimonial home, although it has been bought by one spouse and been paid for entirely by one spouse alone, but because it is a matrimonial home, because there is possibly joint ownership, that might not become a part of the estate. So there is a bit of a conflict over here between Sharia and Ontario law. Also, it is possible that under Ontario law, there is provision for children dependents who are not blood relatives of the deceased. So if a deceased has made a will and under that will they have made a provision for distribution, but that provision for distribution does not take into account certain dependents or children who are not blood relatives of the deceased, then under Ontario law that will need to be rectified. These are certain issues where there is a bit of a conflict between Sharia and Ontario law, but there are various ways in which these can be overcome and this can be remedied. I'd like to speak very briefly about estate administration in Ontario, and after that, I'm going to be, inshallah, wrapping up. In estate administration, essentially means when a person passes away, whether they have a will or they don't have a will, how their estate will be distributed, and what are the various considerations that apply over there. The first consideration is that there is something known as good assets and bad assets. Of course, all assets, if they have some monetary value, are good, but the distinction between good assets and bad assets very simply is those assets which attract estate administrative tax or probate tax, those assets are bad assets. And those assets which do not attract estate admin tax or which do not attract probate tax are good assets. So, good assets are those assets which can very easily be transferred or passed on to the ultimate beneficiaries without having to pay any probate tax on them. For instance, shares in a corporation. For instance, valuable jewelry which can simply be left in a locker for the beneficiaries and does not necessarily need to be conveyed through through the process of estate administration, the formal process of estate administration. Bad assets, examples of bad assets would be real property. Real property cannot be transferred in Ontario until you go through the entire process for probate. The process of probate is that you have to apply to the Superior Court of Ontario to be appointed as an estate trustee. You make a formal application, whether it is testate succession or intestate succession, you have to make a formal application to Superior Court of Ontario to be appointed as the estate trustee. You can be appointed as the estate trustee either because you were nominated in the will as the estate trustee, or you can be appointed as the estate trustee because you are the best person and the closest person to the deceased who ought to be appointed as the estate trustee. The court considers the application. After the application is considered, a judge determines it and issues a formal order of appointment. That certificate or order of appointment authorizes the estate trustee to do everything with the estate just as if he was the person who owned the property. There is estate administration tax, which is 0.5% on the first $50,000 of the estate and 1.5% thereafter. Once the certificate of appointment is issued, then the estate trustee distributes all the wealth amongst whoever is entitled to it, whether it is testate or intestate. And once all of the wealth has been distributed, once all the estate has been liquidated and distributed, then the estate trustee has to go back to court and file a formal report, which is called the passing of accounts, in which the estate trustee accounts for how he made all the distribution, what the various expenses were, and how the process was completed. That brings us to the end. I believe I've covered as much as I could given the limited amount of time. I have a list of frequently asked questions over here, but I understand from Brother Nasir that a lot of people were able to submit questions through WhatsApp as well. And inshallah, I'll try to answer those as well. Do I have any? So I'm just going to hand over to Brother Nasir, and inshallah, he'll take over from here. Thank you.
Assalamu alaikum again. Jazakallah khair, Brother Muezzin Qureshi, for that insightful presentation. I think just an hour is not really enough to cover this vast topic. So I received a lot of questions as well on the Masjid WhatsApp broadcast number. However, it's really difficult to answer all of them because given the time that was scheduled for an hour, we have already exceeded by 10 minutes. So what I would like to do is capture all these questions without revealing the names of the people. And inshallah, when we send the presentation, are we okay to send the presentation? Yes, Jazakallah khair. And also many of them were asking your contact information and you haven't included in the slide. So if you could please include that in the slide, your contact information, then inshallah we can send the slides along with the questions that were asked by the participants and also send them the presentation. Now, before we conclude the presentation, I would like to go through some quick announcements. Primarily, let me just share a couple of okay. So couple of things that we basically do at our masjid is like as you are aware through our website as well as through our newsletter, we conduct daily spiritual talk as well as dua by Imam Arif from 8:25 p.m. to 9 p.m. every day, Monday to Friday or Monday to Thursday. Then on Friday, we have Quran Tafsir by Imam Arif from 8:30 p.m. to 9:15 p.m. But as the Maghrib delays, then this time changes. So please keep track. Visit our website for the updated timings as well as subscribe to our WhatsApp to get the information. Also, we have a Friday speech by Imam Arif from 1:30 p.m. to 1:55 p.m. In addition to that, there's a very important program that Islamic Center of Markham, as well as Jami Masjid Markham has started, which is the COVID-19 support, specifically the food drive as well as the hygiene items drive that we have conducted. And we are basically doing this for the needy. So if you know anyone who is in need of food as well as any kind of support, please visit our website daruliman.org or markhammasjid.ca to and contact them so that we can inshallah help the community as needed. In addition to that, if you would like to keep in touch or with our masjid, we send monthly newsletters, which is um, you can subscribe to our newsletter by visiting our website daruliman.org, as well as subscribe to our WhatsApp broadcast number. As you can see there, 647-995-7000. You will know the procedure when you visit our website daruliman.org. You will know how to add the masjid number as well as how to get subscribed to the broadcast list. There is no spam, it's the broadcast, which means masjid can send the information to you and nobody can see who is on that group. So if you would like to subscribe, please do so. Also, you can connect us on our masjid Facebook page at Darul Iman Mosque. So for more details, you can visit our website, daruliman.org. Once again, Jazakallah khair for your time. We truly appreciate your time. As mentioned, we will inshallah send you the presentation along with the contact of Brother Muezzin Qureshi, as well as a list of all the questions that were asked on the Masjid WhatsApp group. Once again, Jazakallah khair. Assalamu alaikum wa rahmatullahi.